Hey everybody, John Skiba here, and in this video I'm going to share with you some thoughts on whether you should appeal your debt collection lawsuit in the event that you have judgment entered against you. But if this is your first time here to my YouTube channel, go ahead and click subscribe, click on the bell, that way you'll be notified each and every week when I provide you with valuable information on how to deal with your serious debt problem. All right, let's talk about appeals, particularly as it relates to debt collection lawsuits. Here on the YouTube channel, we talk a lot about different tactics and approaches about how to win these cases, but some people are going to lose their case. I lose cases. Any attorney that's telling you they haven't lost a case, they are lying to you. So I want to talk about if you lose, if you get a judgment entered against you, whether you should appeal the case to a higher court and have them make a determination whether your judge got it right or not. Now, because of the type of appeal I'm talking about here, this is not a situation where you had a default judgment entered against you because you didn't file an answer. I have other videos on that, particularly they're entitled How to Vacate a Default Judgment or How to File a Motion to Vacate a Default Judgment. I'm not going to talk about that in this video. This is a situation where you filed an answer and you've been battling these guys. And either you lost based upon a motion for summary judgment where you got a bad ruling against you, or you actually went all the way through trial and the court entered judgment against you at that point. So in determining whether you should appeal the case or not, really depends on which one of those two paths your case took. Let's talk about motions for summary judgment first. This is a favorite of the debt collectors because all they have to do is file a written motion with the court. If you respond to it or if you don't, and if the court grants it, it's done. You don't get a trial, your case is over. The motion for summary judgment is where most people get tripped up in debt collection cases because it's fairly difficult to respond to it. You've got to respond to it substantively. It's not like the answer where you can just admit or deny the allegations. You actually have to go in and attack the evidence and provide your own evidence to be able to win that. So if you have a motion for summary judgment filed against you and you lose, the court enters judgment against you, and you have the ability to appeal. I guess I should say that right from the outset. I know that in some jurisdictions, depending on the amount you're being sued for, you may not even have appeal rights, but I think with most of these cases, you probably have the right to appeal it to a higher court. The first thing you need to do is contact the court. Once the judgment is entered, is contact the court and find out how much time you have to file an appeal from that judgment. These deadlines to file an appeal are black and white. If you miss it, you're done. The appeal is done. So for instance, like here in Arizona, if you are in the justice court system, which deals with lawsuits where the amount in dispute is under $10,000, if a judgment is entered, you have 14 days to file an appeal to the superior court, which is the higher court. If you don't do it within 14 days, it's over. You can't do it on 15 and ask for forgiveness. There's none of that. You got to do it within 14 days. However, by contrast, here the superior courts in Arizona, which deal with lawsuits where there's more than $10,000 in dispute, there you have 30 days to file what's called a notice of appeal with the court to be able to have the Court of Appeals take a look at it. So you need to find out what that period is because it's super important. You need to do some research. You might want to contact the court, see if they can direct you to some resources or even talk to an attorney who can tell you what the specific appeal time frame is. Now, if you appeal to the higher court on a motion for summary judgment, it's important to understand what that can and can't do. First of all, the reason why I like appealing motions for summary judgment rulings is because the courts typically take those and they review your motion or their motion and your response under a standard of review, which is called de novo. De novo means essentially they are taking a look at it without regard to what the prior judge did. They're looking at the motion and saying, were there substantive questions of fact that should have precluded the granting of summary judgment and made this matter go to trial? And so they're kind of taking a fresh look at everything and giving you a ruling that hopefully will be in your favor. It's important to note that even if you win on appeal from a judgment, from a motion for summary judgment, it does not mean your case is over. All it means is they will reverse that ruling from the court. They will, essentially the summary judgment motion will be denied, and then your case will go on to trial. So it's a victory in that you are no longer have a judgment against you, but it's just a small battle. The war is not yet completely won. they're going to send it back to the court where it was and go ahead and set the matter for trial, where the plaintiff's going to have to come in and prove their case. So I like appealing motions for summary judgment when I get a bad ruling, because I get the Court of Appeals or the Superior Court, whoever's looking at it, is giving us just a fresh view of their ruling, what their ruling would be on the motion. The downside is the case is not over. You're going to have to go back and still battle this thing out. Now, it's a little bit different when we look at if you go to trial. If you go to trial, the debt buyer puts on their evidence, you put on your defense, the court rules against you. If you timely file an appeal from that, typically the standard of review is different than that of a motion for summary judgment. When an appeal goes up to a higher court, usually they're going to look under what's called an abuse of discretion standard. They're looking to see, did the judge that was sitting there abuse their discretion, because each judge has discretion on how they want to resolve these things. Did they abuse their discretion to such an extent that it was violated the law? And this is where it can get a little bit tricky, because I've had Court of Appeals judges tell me this in my own cases, that, hey, maybe if I were the judge, the trial judge, I would not have ruled that way, but I can't say that they abuse their discretion so much that I'm going to reverse this case. And so that's kind of the tricky thing, and this is where it is helpful to get an attorney involved. And truthfully, I think when it comes to appealing these things, it's important to get an attorney involved, because it becomes very complicated very quickly, and the deadlines are very harsh. You've got to hit the deadlines or your case is going to be done. But you need someone to help you evaluate it who's been through it before, in determining whether the judge abused their discretion to such an extent that you would anticipate that the Court of Appeals or the higher court that's reviewing this is going to actually reverse it. Now, if you are successful on an appeal like this, the judgment is reversed. Usually that is it. Sometimes they'll do what's called remand, where they'll send it back down and have the lower court to decide a particular issue. But in most cases, if they reverse it, the case is over. They have an option, I guess, to appeal it to a higher court sometimes, depending on what kind of case it is. But in most cases, if you win on your appeal after a trial judgment has been entered, then that's going to be to your benefit, because the case is going to be over. So filing an appeal is a pretty complicated process. It's something I recommend at a minimum you get a consultation with an attorney in your area to help you determine how to navigate that. But the most important thing is, as soon as that judgment's entered, you need to find out how many days you have to file an appeal, because it's sometimes like here in Arizona, justice courts, it's 2 weeks. And that 2 weeks goes by quick, because often they mail out the judgment, and by the time I get it, 5 of those days are already gone. So it's important to find out when that is, and then to really make a determination of whether it's in your best interest to appeal the case or look at other options like settlement or even possibly bankruptcy at that point to be able to get rid of those debts. So I hope that helps and gives you some introduction on appeals and ways that you can deal with them as you're trying to determine what the best route to go forward is. Appreciate you watching today.